Hello, everyone. Thank you for joining us today for our event, Your Immigration Questions Answered, a sit down with a military spouse immigration attorney. My name is Isabel, and I will be your host for today. I am the Director of Programs and Services here at FMSN. And at FMSN, our mission is to connect, support, and empower foreign born military spouses. And our This network was born in response to the experiences of spouses like us who bring incredible strength, talent, and resilience to our military families. But many face unique challenges such as navigating immigration and legal systems, overcoming employment barriers, adjusting to military culture, and often doing it far from their native country and support systems. We exist because too many foreign-born spouses are quietly struggling. They are highly educated but underemployed. They are fluent in multiple languages but feel unheard. They are caregivers, volunteers, and leaders in their communities, but often invisible in national conversations about military families. FMSN is here to change that. We provide training, resources, mentorship, advocacy, and most importantly, a community, a place to be seen, supported, and empowered. Our goal is to ensure every foreign-born military spouse can thrive economically, emotionally, and professionally, no matter where their journey begins. Thank you for being part of this space. Let's build something powerful together. Just as a quick housekeeping, if you have any questions for us, please email us at support@fbmnetwork.org. And for now, I'll just start reading a little bit about our guests. Miss Karyn J. Begin, pardon if
Begin is
I
correct.
begin, Esquire is an experienced U.S. immigration attorney with nearly 30 years of practice in Florida and abroad. As a military spouse who lived in Germany and Italy, she understands the unique immigration challenges faced by military families, federal employees, and U.S. contractors stationed overseas. She's fluent in English and German. Karyn specializes in U.S. immigration law and cross-border cases. We are also joined by Joshua Begin Esquire, who is the founder of Begin Law PLLC, focusing on U.S. immigration law, federal litigation, and consular processing. He has extensive experience representing military families, federal employees, and U.S. contractors abroad, including handling complex immigration matters and federal lawsuits to resolve delayed immigration cases. I'll just, Miss Karyn, I'll let you start and you can begin your presentation.
All right. Well,
Thank you. Thank you.
go ahead.
No, thank you, Isabel. Joshua and I are both attorneys practicing for many years and completely focused on immigration law, specifically how it applies to U.S. military members and their families. Joshua is going to go over in a little more detail the outline of today's program. But basically, yes, I am fluent in German. Yes, I am fluent in English. My educational training and background is U.S. law school. Have been a member of the German Bar Association as a U.S. attorney. And at this time, I'm going to turn it over to Joshua.
Well, hello, welcome everyone. Thank you for attending this webinar today. We hope the information we provide is helpful for everyone. We do wish to inform everyone that this presentation does not create an attorney-client privilege or attorney-client relationship. Please don't ask any questions and provide details that are specific or identifying to your individual situation. There's no attorney-client privilege on a public forum such as this. You may not depend on the information we provide today for the specifics of your case. Each case is unique and specific to the facts of your life. We encourage anyone who has specific questions to reach out to a qualified legal counsel, including ourselves, for a legal consultation to address any of those specific concerns you may have or assistance you may need. As a brief outline, today we're going to discuss immigration as it applies to U.S. military spouses abroad, to those who are serving overseas, to spouses of active duty U.S. military, those who may be stationed locally. We will also touch base briefly on those who your spouses may no longer be active duty, but you're still located abroad, or they may be a GS employee or employed by a U.S. government contracting agency. We'll touch base on AI and beyond that, what's going on with immigration policy today, some of the new developments there, and we'll round out with a brief Q&A towards the end of this session. Please hold your questions till the end of the session. And again, as a friendly reminder, please do not provide any private information that you wouldn't want to be shared publicly. Karyn, I'll turn it over to you to start with consular processing, generally speaking, as it applies to active duty U.S. service members.
Thank you, Joshua. So, active duty U.S. military are individual service members, male and female, who are stationed abroad. And at some point in time, a new relationship or an ongoing relationship becomes solidified and they want to get married. I think that before we even get into the immigration part of it, we have to understand whether or not the marriage itself is valid for immigration purposes. And one of the things that you have to look into even before you get married is whether or not someone's past history of marriages and divorces, if those exist, have actually been resolved appropriately. I cannot tell you how often Joshua and I will sit in a consultation and come to find that someone has not successfully ended a prior marriage and thought that it was simply okay just to sort of sweep it under the rug. All of these things come to light, and you should be aware of that. So moving forward, past the history of someone's marriages and divorces, let's get into the new marriage. Well, first of all, the marriage has to be a valid marriage for the purposes of where the people are physically present at that point in time. Are you in Germany? Are you in Japan? Are you in Korea? We're talking about consular processing right now. Where is your spouse? Is your spouse physically present with you in the same country? Are you both near or around U.S. military base? Or is your spouse in another country? Are they in an African nation? Are they in an Asian nation? And the reason I say these things is because, or I bring up these points is because you have to understand that if the place where the two of you get married, you have to have the marriage legally valid for that jurisdiction. And that means that if I send in a case to U.S. Embassy Frankfurt, or if I send in a case to U.S. Embassy Seoul in Korea, they're going to want to know if, when the marriage took place, if it was a legally valid marriage in the location that the two of you got married. And that's, of course, why we have a lot of people who run to Denmark. We have proxy marriages. And yes, a lot of these are legal, they're appropriate, and it's just you need to do your due diligence and your homework. And so you're starting even before you've even gotten married to make sure that you're doing the correct thing. I always equate immigration as a very long road. It is a plan for a family. And it's not the only reason people get married. Obviously, people get married to build a life together, to have a common goal and future together. But immigration is that long goal that needs to be addressed in a framework. You have to go step by step. So starting with the first step, do not make a mistake on whether or not the marriage is correct and whether or not the past history of an individual has been sufficiently closed out. Okay, let's move on. You've gotten married, and the two of you have a lawful marriage certificate. And now you
Um,
start, yes,
Karen, if I may interject there,
sure,
about the marriages themselves, you also have to consider what happened in the past for prior immigration applications, if prior
correct.
petitions were ever made, because if things were done incorrectly in the past, unfortunately, what is provided to immigration continues with that person throughout their entire immigration process and beyond. So it's very significant to those points as well. So it's something to consider when you put forward that application. Are there things that need to be clarified from prior applications, or you need to be prepared to answer questions on maybe why a prior application was previously withdrawn or denied, or other additional reasons?
A lot of our clients will say to us in a consultation or going forward, but I'm filing a new application now. I need to be looked at as to what's being happening now. The answer is no. USCIS looks at you as a whole, as everything that was previously done, previously filed, and extending to your family members, parents, siblings, aunts and uncles, and so forth. So we do a global review. So let's moving forward from that. You're now married. Let's talk about being overseas, U.S. Consulate filing. There is a very specific process for filing the immediate relative petition. It's the I-130, and for a U.S. citizen spouse, it's an I-130A. Remember, we are dealing with the basis that your military spouse or contractor spouse or GS spouse is a U.S. citizen. Legal permanent residents are a different story. So they're a U.S. citizen, which means you can file right away. They're living in a particular location. So here's the first question. Are you both in the same country at the same time? Are you both in Germany? Are you both in South Korea? Are you both in Japan? Where is it? If you're both there, wonderful. There, it's a no-brainer. You're filing at the U.S. Embassy where you're locally at. Can you
To
file?
clarify, we're
Yes,
discussing about active duty military
correct.
because these rules change depending on active duty or U.S. government contractor spouse. There's a separate set of
Yes,
criteria to
yes.
apply directly if you are not active duty.
So, I don't need to go down filling out an I-130 form and an I-130A form. The JAG at almost every base holds a monthly session in which they go through the forms with you. They themselves cannot provide legal advice about the nuances of a person's case or the nuances of someone's background and whether or not they should be filing and whether or not they have something that needs to have a waiver, a forgiveness filed for because they have a criminal history or they have a prior arrest or they have some other issue. But when we talk about the most basic source, it is filing an I-130, I-130A, and the filing fees and the evidence of the relationship, of the bona fide marital relationship that the two of you are involved in a relationship for the purposes of building a life together. And each U.S. Embassy has a specific instruction sheet that they send out that is easily accessible to you of a check mark. I need this, this, and this. We find that people become great friends on Facebook, friends with people on their different Facebook groups who offer to help them because they've done it before. I think it's wonderful when people support each other and when they support each other filling out forms. The problem occurs when there are issues, and this is what we encounter as attorneys, when there are issues specific to a family or an individual that we drag out of them that information. They may not even readily share it, or they may not even know what questions to ask. And so when we do that, we determine if this is going to be okay and is not going to put the person in a position that they arrive with the applications filed at the U.S. Embassy with any kind of negatives. We're trying to make sure that we don't have any negatives going in. But in I-130, I-130A, photographs, evidence of the marital relationship, sent to the right location according to the instruction sheet from each U.S. embassy is absolutely correct. And it's a correct basis to start if there are no other issues. Let's move on from there. Consular filing, U.S. citizen, it's been sent in, they acknowledge receipt of it. The first thing I want to tell you is please make a copy of everything you've mailed in. That includes a copy of the money order or cashier's check or bank check that's sent in US dollar funds to the US Embassy. We have so many people that never make a copy of what they send in. It has to be scanned or photocopied every page. Everything sent to a US Embassy has to be single-sided page, no double-sided printing.
And it
And
all
it,
must be printed in color.
yes, 8.5 by 11. Okay. Um, once it's filed, you should receive an acknowledgement from the U.S. Consular Office that they have received it. Please make sure that you're using an email address for both the U.S. citizen spouse and the foreign spouse that you are monitoring regularly. Okay. And
On the topic of email addresses, please do not use any government or company
yes,
email addresses.
yes.
All information on those email addresses are subject to what's called a FOIA, Freedom of Information Act request, and can be discovered by anyone in the public, and also breaks any sort of confidentiality or privileges you may have on your filing.
Do not
So
communicate with each other through your employment email address. Please create generic emails that you're using only for this purpose, or it's your regular email that is not a work-based email address. So anyway, at a certain point, as an example, Frankfurt has a 6 weeks processing time. Within the 6 weeks, they'll generally send you out notification if it's satisfactory and if they approve it. Wonderful, you've passed through the first hurdle. They will also either send the entire package back to you if there's a problem with all of it, or they'll send you an email advising you of what is insufficient, what's lacking, and what they need. And you have to get it to them right away. Um, Everything that you mail to a U.S. embassy should be with delivery confirmation, with a signature confirmation. Please make sure you do that. Please, again, make copy of everything else that you send with proof of having mailed and following up that it was actually delivered. So now
Karen, real
yeah,
quickly on the consulates, we've noticed that a lot of people um, tend to rely on the communications they've had with the different consulates.
yeah.
The consulates, they are not an attorney there to assist you. They will try to help and assist, but just because a consulate officer told you one thing, and if they were mistaken, does not necessarily create some sort of special circumstance for you. So we've had issues with that. Also, we've had issues where people are contacting the wrong departments at consulate, so their emails, their communications go into a void. And it can be quite confusing, and it's different for each and every consulate who to contact, whose names, what emails, what phone numbers. And it's not really possible to provide anyone a list of that because it's a case by case and it changes frequently. From one month to the next, they may not no longer use that communication in order to contact them for your type of specific issue, as opposed to just general questions.
Um, at the point that your case has been approved, U.S., it's actually not USCIS, it's the Department of State, it's the U.S. consulates who are then sending out an informational as to the next steps that need to occur. And those are generally have steps that include online application with the Department of State. It is the DS-260 form that has to be filled out. And know that before you ever hit submit on that form, if there is something that is incorrect, it is extremely difficult to change any of the information that you submitted on it. It's almost virtually impossible. You can ask them to reopen the form, they never respond. It goes on and on. You have to do a medical exam. And people always ask me, what's the timing of the medical exam? The timing of the medical exam is when your case has been approved and you move on to the next step, which is filing and doing completing your DS-260, and you have to notify the consulate that you've completed that so that they can open up the scheduling window to schedule an interview. Who's going to interview? It is the foreign-born spouse. That's who's going to interview. And when that appointment window is open, and if that particular consulate office allows you to schedule or select your own date for interview, please be aware that before you go to interview, and when you've scheduled it, the actual date, that is what you have to use to make an appointment at the medical office. The doctor's office has to have an interview scheduled, and it has to give them enough time, which is a couple of weeks, to do your medical exam and provide the results to the U.S. Embassy. Okay. And you will not be granted residency, and your case will be put in delay and in a backlog if you have not completed the medical exams appropriately. We're not the medical team, but I just want to give you a brief overview. Please, if you're thinking about moving forward with your case now is the time to put together your immunization vaccination history. If you do not have it, to bring it to the medical office. They're going to start from square one, and they're going to give you all the vaccinations from the beginning. The doctor's office will determine what vaccinations are necessary based upon your age, your sex, your medical condition, and what you've had in the past.
There are only select approved physicians based off of each country, and you can only get the review done by those individuals. Having an X-ray done or any sort of medical review by another physician will not qualify. Now, that's not to say your past vaccination records, and if you have other vaccinations completed, as long as it was done correctly and you have proof of that to provide to the approved physician, and that's a different story.
I'm going to bring up another point. I'm sorry. I'm going to
Mhm.
bring up another point now. We've talked about how simple it is to file the I-130, the I-130A. You get approved, you go to a scheduled interview. Let's stop at the medical exam. If you have a pre-existing condition, a pre-existing medical condition that warrants the need for extreme medical care, it is a facet that the U.S. consular officer who is interviewing will review to determine if you're going to become a financial burden upon the U.S. government and whether or not to admit or deny your residency to the United States. And you should be aware that if you have a past history of drug abuse, being confined to an institution, whether it be a psychiatric institution or a drug rehab or an alcohol rehab, these are issues, among other medical basis issues, that you should probably get legal consultation before you move forward to determine how to address this, whether and how to approach it. We work with what's called damage control, mitigation of the presentation of a particular issue. And that's what it's about, is whether or not it's being properly presented, and how the statements need to be made to the doctor's office to present yourself. Because the doctors are in a rush. They're moving through their medical exams. And if you, and as an example, if you say, I used to drink a lot, and I used to, my husband, when he was on deployment, I used to go out with the ladies and we had drinks. This is an example only. And we used to have drinks every Friday and Saturday night, but I don't do that anymore. And the doctor says, well, how often did you drink? And you say, oh, we wouldn't have more than 5 or 6 for the night. And you did this every week. And the answer is, oh, yeah, but we don't do that anymore. He's not on deployment. I'm okay. I'm good now. This is not a conversation to have at that point. Uh, okay. Medical exam is completed. Applications are filed. Interview is scheduled. And now you're going to go to an interview. What's the first thing you're going to do? You're kind of going to call all of your friends or all of your new Facebook friends, and you're going to ask them all what happened at your interview. And you're going to want to know what they went through and the questions that were asked of them and how they responded. You're going to jump on Instagram and you're going to find someone who's got a paralegal notario immigration help center office, and they're going to have a video telling you what you should say and all of the things you should be forthcoming with and how you should respond to things. Remember, brevity is the key, number one. Disclosure of things should be related to your life with your spouse. And if it comes to matters that are legal issues and could possibly render denials, then you seek legal counsel. You don't resort to taking social media assistance or people who've been to interviews. Every person has a unique interview. A lot of the interviews take place on the counter in the consulate office, in the room with all the other people sitting in the waiting area in their chairs. They rarely, if ever, take people into an office in the consular setting. And so you need to know what you're stating and how you're presenting yourself. By the way, U.S. attorneys are not allowed inside the U.S. consulate. Many, many years ago, when I first started practicing, we were able to do that. And I did indeed fly to consular offices for this. But it's been more than 2 decades that we have not been allowed to attend interviews. And so you're on your own 2 feet there with an officer who has basically about 15, 20 minutes to decide if they're going to grant your case or not. So everything needs to be brief and it needs to be done succinctly, okay? Quickly.
It's important that the application is prepared, complete and accurate, but with the necessary information. They do a good job by providing an outline of what to provide and what is
Yes.
required,
The consular
which
officers, yes. Yeah.
which is the mandatory minimum. Sometimes there's additional information that may be better to provide, because you want to make sure the officer has a complete understanding of your relationship. Because generally, by the time you get to the interview, the officer may have reviewed and already have a decision or an idea of where this is going before you step foot in the office based upon your filing. And you're there to either confirm or deny or any other additional questions that they may have so they can make their determination. At the time of the interview is not the time where you should be trying to clarify any confusion because of a mistake in what was presented or filed, or the documents themselves were just a little confusing in how it was presented. Because it can get confusing. A lot of the consular officers, they could have prior military experience. They should all be familiar with the types of documents that they need to review, but that's not always the case. So they may be trying to understand new documents.
I just want to bring out something that we haven't touched on yet is whether or not an individual who's applying for residency to the United States through the consular office had a prior residence in the U.S. or a prior visa. And if you've overstayed on a prior visa, or you've been in the United States and were deported, removed from the U.S., you have any immigration history at all that has any negative outcome to it, this webinar cannot focus on that. And this is a moment in time where you do need to seek legal advice.
I think
Just,
we need to move on a little bit.
okay,
We're
sure.
starting to
I'm
run
sorry.
long here.
Yeah, yeah.
So you go to the consular interview, which is a very significant step in getting to that point. But let's say the consular interview is completed. You are now approved. Yay, congratulations. What happens next? So you're approved. Now you need potentially an entrance into the US in order to validate that visa. The entrance into the US has to be completed prior to the expiration of that visa. If it is not, it's done. Karyn, do you want to elaborate?
Yes, the visa is not valid for 6 months. The visa is valid for 6 months from the date of your medical exam. So there's an actual expiration date on it. You've gotten your visa, I'm sorry, your passport back in the mail. It has the visa stamped in it. And please look at the expiration date and then make plans for entry to the US, even if it's 24 hours, whatever it's going to be. That's fine. But once you enter, and you've paid your immigrant visa fee before you enter the United States, you must pay the immigrant visa fee, which is an additional fee that happens after receiving your legal permanent resident grant of residency. Okay.
Mhm.
Um, because when you enter the US, if that fee hasn't been paid, then your card won't be created and your social security number will not be issued. You don't have to remain in the United States waiting for your resident card. You don't have to remain in the United States waiting for your social security number. You can fly back overseas to be with your spouse. And the secure address that you've provided for mailing, which should be a family member, trusted friend, intended address to return to, that is the
There,
address. Yeah, that is the
yeah,
address where the card will be mailed. They will, 99% of the time, we have an issue with people putting down APO AE addresses. Oh, and I'm sorry, I would need to bring that up. That was something that Joshua and I have discussed time and time again. People think that APO AE addresses are actual physical addresses. They are not. That is a mailing address only, and you cannot use the APO AE mailing address for the consulate to mail you anything. You have to use a physical mailing address for them to mail you something physically within the country. And if you use an APOAE as your physical address, it provides a huge source of confusion. And we'll get into that later. But it provides a huge source of confusion as to where you're physically located. And they will not mail a resident card and social security information to the APOAE 99% of the time. You've now entered the United States. You've gone into secondary inspections at the US airport. The officer confirmed all of the information with you. They just need 20 minutes or a half an hour to enter stuff into the computer. And voila, you are a legal permanent resident of the United States. The next day, you can take a flight back out. Your visa in your passport is the evidence that you are a resident. And
um,
yeah,
to clarify there, when we say you're a legal permanent resident, it's specific to an individual and their case and the length of their marriage.
that's right.
And so there are multiple steps to residency. If the visa and the status is granted prior to 2 years of marriage, you are then what's called a conditional resident. Once you are a conditional resident, after a certain period of time, you then have to apply to become a permanent resident of the US. And then after the requisite period of time, you can apply for naturalization. So you're
The
not
acronym, yeah,
always a permanent.
the acronym,
Mhm.
acronym is commonly known as a CR1. And so a lot of spouses trade that verbiage to understand that or think that they're filing the CR1 process. Some people have been married longer and therefore they are IR ones and not CR ones. But you had to have been married for more than 2 years at the time of the interview and being granted the residency, not at the time of filing. Something we haven't discussed is the timing for when does one file an immediate relative petition for people who are active duty overseas. It's usually tied to when you intend to PCS back to the United States. And just remember, we need to make sure that there's enough time provided to the consular office and for any request for additional information and any hiccups to allow the process to go through within the time frame that you're going to be departing. And we have had military members who have had to leave because they were suddenly called up and their spouses had to remain overseas, and it's created a lot of problems. So at a certain point that you are married with a foreign spouse, you need to be taking a look at how much longer you have on your contract, on your orders there, but also what could happen is an eventuality if you were removed or relocated. So that's something to look at, and I can only tell you is please don't delay.
The immigration process, it's really about long-term planning. The processing times can vary. They're subject to change based off of the Department of State's capacity to move through the work, how many applications. So they can one time be 6 weeks, they can be 10, 12, and they can jump around. So there are, in certain specific circumstances, ways to expedite certain applications, but that's really on a fact by fact basis, and it has to be reviewed to see if it meets multiple criteria, which is a little bit beyond the scope of this presentation and is better reserved for review with an attorney because it really has to be reviewed individually.
One last statement with regards to overseas consular processing for I-130. What happens if your case is approved, you've gone to interview, you've traveled to the United States, you return to your spouse, you either live on base, off base, whatever, they're active duty, and they have a separation from the military. What happens to your status as a legal permanent resident if your spouse decides, honey, sweetie pie, we're going to live overseas? I've decided that we're going to live overseas because now is not the right time to take our children out of school. Now is not the right time to go back. I think I can find a job as a contractor. This is, I posted about this on some Facebook forums, and I had at least 3 people come back and say to me, this is false information that you're providing, that you're saying that it's a problem, but that's false information. It's not a problem because you're still married to the US citizen, even though you're overseas. That's not true. You can actually lose your residency if within a certain matter of months, not years, the US citizen spouse doesn't relocate back to the US or enters on some other type of independent status that places them working overseas for a US company, not a foreign company, but a US company as a contractor.
That
You can
that
actually, yeah,
supports the
that
U.S.
supports,
government and not just another company that happens to be a U.S. company. It has to be in relation to the U.S. government.
right. These are very specific cases. Again, if you and your spouse, if you're a legal permanent resident, you're living with your spouse overseas, your spouse is going to separate from the military, please take legal counsel in order to talk about the specifics of your case, where you're headed, and the plans to maintain your residency. And in some cases, people fill out applications for reentry permits and don't realize that they have to be physically present in the United States to do the reentry permits. And so these are just other topics, but I think we need to go past it and move
Yeah.
now on to the topic of filing a petition domestically in the United States, which is the I-130, I-485 in the US. Joshua?
Um, we're running 15 minutes till.
Okay.
I think because I think we're better off focusing on abroad at this point because to open up a whole nother conversation on in-state filing. I mean, I see some questions here about parole in place. And maybe this is something we make some notes of and we have another meeting on where we focus on an individual topic. But
Isabel,
Okay,
this is your company's webinar and you're hosting it and we'd like to defer to you. Would you like us to continue with future webinar then on the next topic and the next topic? Because there's so much information in each topic.
I think if we stop the recording now and at least just if we could answer some of the questions, because I know
Yes.
some, yes. So I will stop. Thank you so much for your presentation. I will stop the recording now.